You know. The House Families and Veterans Committee will come to order. Would the clerk please take attendance?
Chair Schmaltz.
Here.
Representative Wozniak.
Here.
Fox.
Present.
Johnson. Here. Thompson. Here. Pavlo.
Here.
Wolford.
Here.
Young. Here. Burns.
Here.
Rindings. Here. Song. Present. Madam Chair, you have 11 members present. You have a quorum.
Thank you, Madam Clerk. Representative Young moves to adopt the minutes of the April 14th meeting without objection. So ordered. The committee will stand at ease at the call of the chair.
committee will return to order. Our next order of business is to hear testimony on House Bill 5739 and 5740 from Representative Schmaltz and Representative DeBoyer. Please proceed.
Thank you, Chair and Committee. We've all heard the reports of individuals whose guardians or conservators take advantage of them and exploit them financially. It's terribly sad, and it happens way too often. These bills aim to stop this and protect some of the most vulnerable individuals. House Bills 5739 and 5740, sponsored by Rep. DeBoyer and myself, close the gaps in current law that leave significant financial assets without adequate oversight. First, it establishes a threshold. When someone has $25,000 or more in liquid assets, safeguards are triggered. If a guardian becomes aware of assets at that level and no conservator is in place, they must notify the probate court within 14 days. The court is then required to appoint a conservator to ensure proper financial management. Second, the bill strengthens financial accountability. Conservators will be required to either post a bond or use restricted financial accounts, ensuring that funds are protected and traceable. In addition, financial inventories submitted to the court must include supporting documentation, such as bank statements, pension records, or Social Security statements, so there is real transparency, not just reporting on paper. Third, this package clarifies authority and responsibility. Guardians and conservators will have clear authority to assess financial accounts, freeze them if necessary to prevent loss, and establish appropriate accounts to manage income and expenses. It also ensures that proceeds from significant financial events, such as legal settlements, inheritances, or the sale of property, are properly deposited into accounts overseen by the conservator. These are not sweeping changes. They are smart, focused improvements. They give probate courts better tools, create clearer expectations, and close gaps that currently leave room for financial harm. Most importantly, this legislation is also about prevention. Once exploitation occurs, the damage can be devastating and often irreversible. By strengthening oversight on the front end, we can better protect individuals who may not be able to protect themselves. It's about dignity, accountability, and trust. When the state appoints someone to care for another person's well-being, including their finances, we have a responsibility to ensure they're protected. These bills help meet that responsibility. And I'll turn it over to Rep. J. DeBoyer.
Thank you, Mr. Chair. Thank you, Chair Schmaltz. First, thank you for the work you've done on these. You've put a lot of effort into them, and I think they're meaningful. I think they're rather simple. I think that they're needed. For too long in the probate era, there's been, kind of trust with no verify. And I think all of this does is create a scenario that things are transparent, things are on the up and up, and it gives everybody a little bit of peace and certainty. 5739, which is my bill, what that one simply does is it creates a requirement of a bond to be posted, which I think is reasonable. There's definitely an issue that's going on within this structure. As you may be aware, the House Oversight Committee just within the last year looked into some allegations through the Attorney General's office that there had been some wrongdoing by a Ms. Tracy Kornack, who was a individual who was caring for a individual who was functional and had their faculties but needed some assistance with the management of their finances. And as it turned out, at least based on the evidence that is provided to us at this point, that Ms. Kornack had taken advantage of Ms. Rosenberg to the tune of in excess of $400,000 of questionable transactions, as well as some things that, again, are pretty disastrous for Ms. Bird, which included identity theft, presenting false pretenses, acted as a personal representative when those authorities didn't exist. It's just a very egregious case, and there's been many other cases. And I think that by putting these common sense things in place, amending these statutes, I think that it will help to prevent these things moving forward. So I appreciate your time considering these bills to everyone on the committee.
We have questions. Rep. Song?
Thank you, Chair, and thank you so much for your testimony, representatives. My question is regarding the $25,000. How was that number determined? Is that the average? Because I think that there are some assets that 10,000, 15 is still a significant amount as well, too.
Well, of course, there's different amounts you can consider, but the Guardianship Association came up with the $25,000, which we thought was a good amount.
All right, thank you. Thank you, Chair.
Lower than 25,000, there's no requirement, but the judge still could order a bond.
Right.
When they're ordering a bond, does the conservator then have, or well, is it both the conservator and the guardian?
Yeah.
Okay.
Yep.
So, once the judge issues a bond, does the conservator automatically have access to manage that property?
If they're so granted that authority, yes. But it has to be managed through secure accounts, documentation. Right now, there's not a requirement of documentation. It's a lot of times, as you may be aware, you've been dealing with this for a long time. It's essentially just a document that it gets filed with the court. There's really not necessarily any supporting evidence. It's really trust but not verify. And so I think that in light of the circumstances that we've seen, that many people of the state of Michigan have seen with their loved ones, I think that these just simple parameters are they make sense. They're not going to impose any hardship on anyone to do them, and I think it just makes everybody have a little more peace of mind, especially if it's your loved one, right? That might be in a circumstance like this. So,
And Rep. Schmaltz, on your bill, does it only affect professional guardians and conservators, or does it affect all?
What'd you say? I believe we're talking about professional guardians here, yes.
Only.
Yes.
So the judge would still have his discretion for a family member that's a conservator guardian?
Yeah, here, Penny.
We might
I
want to
think
defer
it's
that
actually-
question. We have two other
Yeah.
testifiers coming in. We have Jennifer Warnos and Brooke Gow, both who represent guardians, and they might be have a better understanding on how that would work.
Thank you for that input.
so I think it's important to note that under the current statute, the judge always has that discretion
Right.
to issue orders that require the guardian or a conservator to do certain things. But what this does is at least put some guardrails in that says if you are a court appointed or otherwise, you have to comply with these things.
Yeah, and this wouldn't affect the real estate at all because there's other rules for that, and the movement of the ward, correct?
Right. It's most specifically concerning is anything that's a liquid asset that could be sold quickly without much record, or bank accounts that have cash balances in them.
Representative Fox.
I'll hold mine till after the other testimony.
Okay. Representative Johnson.
Thank you, Mr. Chair. I just want to say thank you for bringing this forward. Anything we can do to improve the whole process and bring more accountability is good. I've just been horrified the last couple of years at watching processes that should have just been stopped. They should have been caught, but they weren't because we don't have these checkpoints, and I appreciate it. Thank you.
Representative Thompson.
Thank you, Mr. Chair. Thank you both for this legislation. When we see situations like this in which financial abuse occurs within these guardianship conservator cases, what is the family's alternative to file any type of complaints? You happen to mention the Attorney General. So was this case taken serious, or is the Attorney General working with you to resolve this?
Specifically, the case that I referenced, there has been criminal charges charged in Kent County on Ms. Cornack for the abuse and the taking advantage of this individual. So that's all pending right now. Those charges have been filed and it's in process.
Okay.
Yeah.
Thank you.
Representative Young.
Thank you, Mr. Chair. Thank you. Thank you both for bringing this important legislation before us today. It says in the bill that the guardian is required to report this additional cash or property to the court within the 14 days, which is we kind of trust them to do that. But if we find that they didn't, if we find that they've had this information for 6 months and didn't say anything, what happens? I wasn't sure about that.
I would say that the judge would have any sanctionability that they would normally have. So if, theoretically, it could end up as a contempt position from the judge if you don't abide by the rules. And it is important, and thank you for pointing that out. That's an important aspect of this because, as you know, properties may be sold and converted into cash during this period. Well, now they become subject to that liquidity position, and the requirement to report that, I think, is a very important piece of this legislation. But thank you. That's a great question and great point.
And the judge would still have the ability to discharge the
Sure.
guardian or conservator.
Of course. Yep.
Okay. Any more questions? Rep. Wolford.
Thank you, Chair. Thank you both for this legislation. It's so important. Everyone has not had access to the type of oversight committee that we've had in reference to this Cornett case. And I wonder how many times that this has happened to others. And I know this legislation will stop that. And then also, how many times that it's happened and it was brought up and then pushed to the side. So thank you for this legislation. I appreciate both of you.
Thank you. It's all about protecting our vulnerable people, and we hear these stories all the time, and none of them make the headlines. Only a few of them actually get there, but it happens all the time, so we really need to do something to stop it.
Burns? Oh, Burns. Representative Burns.
Thank you, Chair Wozniak. Thank you both for your testimony and bringing this legislation forward. With regards to House Bill 5739, it looks like a requirement was removed, the requirement being previously that a bond be furnished or that a bond furnished by a conservator is conditioned upon the faithful discharge of all duties of the conservator's trust, according to law. It looks like that requirement was removed as a result of the bill. Just curious the thought process behind that and if you can speak to that for us.
Yeah, let me reread it really quick.
Sure, thank you.
So I think to a degree you have to realize that was in the context of the previous, the judge had the may. So if there was a may, it set forth the condition upon faithful discharge of all duties of the conservator's trust according to law, right? This is now a must. Okay. So you have to do this now, so therefore you're going to behave in a manner that's going to be at the discretion of the judge all the way through the process.
Okay.
Where before it was the judge might issue it, but how do you get out of it? You get out of it by doing this. You can't really get out of it now.
Okay, so it removes the wiggle room essentially.
Correct. You're
Okay.
locked in now.
Thank you.
Yep. Which I think is important. And again, that's a great question. I think it's important because anybody that's dealing with someone else's finances should have we should be able to look at them, right? Make sure that they're doing things the appropriate way.
Sure.
But thank you.
Thank you for that clarification.
And I know in other legislation we've got, judges are more looking at delineated guardianships and conservatorships rather than have a full guardianship or conservatorship, which I think is important, and everything on the record. Thank you, representatives.
Thank you.
Thank you, Mr. Chair.
Committee will go at ease. I can't hear very well.
Okay. The committee will return to order. Our next order of business is to hear testimony on House Bill 5739 and 5740 from the Executive Director of Guardian Finance and Advocacy Services, Jennifer Warnes, and Executive Director of Family Service Agency of Mid-Michigan, Brooke Gow. You can start. Just push the red button.
Thank you. Thank you. Chairwoman Schmaltz and members of the committee, Thank you for the opportunity to testify on this important policy issue on behalf of the Michigan Guardianship Association. The bipartisan legislation before you, House Bills 5739 and 5740, represents a significant step forward in protecting vulnerable adults. These bills establish clear financial safeguards for guardianship and conservatorship cases with the critical goal of preventing financial exploitation before it occurs. Notably, this is among the first legislative efforts in Michigan focused on prevention rather than solely punishment after harm has already been done. My name is Jennifer Warnos, and I serve as Executive Director of Guardian Finance and Advocacy Services. Since 1966, Guardian Finance and Advocacy Services has provided guardianship and fiduciary services to vulnerable individuals in Kalamazoo and Calhoun counties. Our guardianship nonprofit program currently serves 365 individuals annually, and our agency serves over 1,100 individuals throughout our various programs. I have worked in the mental health field for over 20 years and have 11 years of guardianship experience with Guardian Finance and Advocacy Services.
Okay. And hello, everybody. My name is Brooke Gow. I'm the Executive Director of Family Service Agency of Mid-Michigan. Since 1945, our agency has provided professional, no or low-cost services across 7 different program areas to support individuals, families, and older adults in Genesee, Lapeer, and Shiawassee counties. To date, we service around 7,000 adults with disabilities every single year. Our guardianship program serves approximately 200 individuals annually, providing critical advocacy and support to vulnerable adults. With 10 years in the guardianship field myself, I bring a unique perspective, having worked on both sides as a public guardian and a full-time guardian ad litem for Lapeer County Probate Court. This experience allows me to see both the reasons for the outcomes of guardianships, often in systems with limited oversight and regulation. Last fall, fellow representatives of the Michigan Guardianship Association appeared before this committee to advocate for licensure of professional guardians and conservators. We appreciate this committee's leadership in advancing that legislation and look forward to its continued progress. Protecting the financial assets of vulnerable adults is the next logical step in strengthening Michigan's guardianship system. To provide helpful context, in Michigan, a guardian and a conservator serve distinct but complementary roles within the probate court system. A guardian is appointed to oversee the personal care and well-being of an incapacitated individual, while a conservator is responsible for managing that individual's financial affairs. These responsibilities may be assigned to the same individual or be divided between separate parties. Nationwide, the term conservator often refers to both roles combined, depending on the state. Unfortunately, financial exploitation of vulnerable adults remains a persistent and troubling issue. Reports of individuals losing their life savings, funds accumulated over decades of work and careful planning, are far too common. These assets, intended to support individuals in their later years, are often misused or stolen, leaving victims with limited resources and a diminished quality of life. Even when perpetrators are identified, recovery of these funds is incredibly rare. National estimates suggest that more than 90% of these cases involve individuals known to the victim, such as family members or close associates. While instances of misconduct by professional guardians or conservators do occur, in many cases, by the time a professional is appointed, the individual's assets have already been depleted. Regardless of who manages these funds, policymakers have a duty to ensure that appropriate safeguards are in place to protect vulnerable individuals. And these bills represent a meaningful step forward that fulfill that responsibility. Importantly, this legislation applies to all adult guardianship and conservatorship cases, regardless of whether the appointed individual is a family member or a professional. It does not apply to guardians of minor children or to individuals informally assisting with financial management without a court appointment, such as a power of attorney.
These bills introduce several key reforms. First, they require guardians to notify the probate court within 14 days if they discover liquid assets of $25,000 or more in cases where no conservator has been appointed. This ensures that the court is promptly informed of financial resources that require oversight. Second, they require the appointment of a conservator whenever liquid assets meet or exceed $25,000. While some counties already follow this practice, these bills establish a consistent statewide standard. Third, and most critical, they require professional and family conservators to either post a bond or utilize restricted financial accounts when managing assets at or above this threshold. A bond functions as an insurance policy protecting the individual's assets, often at a relatively modest cost compared to the value safeguarded. Restricted accounts are also a cost-effective method to protect assets. Under this system, funds necessary for routine living expenses are maintained in an accessible account, while remaining assets are held in a restricted account. Withdrawals from the restricted account require court authorization, ensuring judicial oversight of significant financial transactions. The legislation also strengthens reporting requirements by mandating that inventories submitted to the probate court include supporting documentation such as bank statements, brokerage statements, and benefit records. While this will increase conservators' administrative responsibilities, it significantly enhances transparency and accountability. Additionally, the bills clarify that proceeds from the sale of titled assets, such as a home, as well as funds from settlements, inheritances, pensions, or trust distributions, must be deposited into accounts under the conservator's oversight. This ensures that all significant financial events are subject to appropriate monitoring and court direction. While these provisions may seem technical, they address critical gaps in the current system. Together, they create a framework that prioritizes prevention, oversight, and accountability. Ultimately, this legislation is about protecting individuals who are no longer able to protect themselves. Preventing financial exploitation is far more effective and far more just than attempting to remedy harm after it has occurred. In closing, I would emphasize that many of our community partners affected by these policies support these reforms. No one should lose their life savings to exploitation, regardless of whether the perpetrator is a family member, a friend, or a professional. These common sense measures allow the Michigan legislator to take a strong and necessary stand against financial abuse. As guardians and conservators ourselves, we do represent the guardians and conservators who would work under this new law, and we do support it. And thank you for your time and consideration. We'd be happy to answer any questions.
Okay. Yes, we have a question. Rep. Fox?
Thank you, Madam Chair, and thank you for your testimony. Just one quick question. I totally understand the intent of these bills. I worked for many years with older adults in my county, but wondering about the burden on the courts. Will this requiring of bonding or restricted accounts or actual bank statements, is it going to overburden the courts?
Thank you for your question. That is one that seems to continue to arise and pop up. And I'm intentionally here today from Genesee County because the majority of our guardianships do operate out of Genesee County. And this is a practice that has been ongoing in my county for some time. I work very closely with our probate court administrator. And when I had a conversation with him about this bill that we are presenting and would like to make the standard for Michigan guardianships and conservatorships, he was relatively shocked that it is not already the standard, or at least a best practice in probate courts. And what he explained to me is that the majority of courts in the state of Michigan have a system in place that would notify the courts if and when there is a deficiency. So at the initial appointment hearing for the guardianship or the conservatorship, if there is a presence of assets, liquid assets exceeding $25,000. It is common practice in Genesee County for the $25,000 plus dollars to be placed in a restricted account or a bond be carried by the guardian or the conservator. And the way that they track this is once that order goes in place and the guardianship or the conservatorship is appointed, they have 2 weeks to provide proof to the courts that those funds have been moved to a restricted account. In the case that that is not completed within 2 weeks, similar to other documentation that's already standard and required in all courts, such as an inventory, if it does not make its way to the probate court within 2 weeks, the court's systems themselves generate notices of deficiencies, in which case the courts are notified and they would show cause that individual and bring them in for testimony and find out why those accounts have not been restricted. So the infrastructure, as far as I'm aware, to best answer your question, already exists.
Just quick, so you're not expecting any fallout in relation to the courts and their responses to this?
I can speak for Genesee County at this time, and they are in full support, and as I stated already, practicing this. This is also a bill that we've had many conversations with a lot of different partners, and our Michigan Guardianship Association is a very large association, and this is very widely supported. Thank you.
We have a couple more questions. Again, this does cover all guardians. I just wanted to repeat that. Rep. Wozniak?
Thank you, Madam Chair. Brooke, I think you mentioned you worked as a guardian ad litem.
I did, yes.
Is the guardian ad litem required, and I don't think it's required, to do an investigation on the assets of the ward?
Correct, yes.
You're required to do that?
Yes.
Okay.
That was a part of my role as the guardian ad litem in Lapeer County. I'm not sure if that's law, but that was one of the main things that I was looking into for that individual. Lapeer County also operates with a guardianship and a conservatorship process. There were many instances where somebody might have been suitable to serve as a guardian, but might have been questionable as a conservator, in which case we would have appointed a second party for that conservatorship.
Right, and those would go in your report?
Correct.
Okay, good, thank you.
Thank you, Rep. Young.
Trying to get some clarity. Thank you, ladies, for coming in and helping us understand this better. So one of you all, forgive me, but one of you all talked about either, I thought it was an either or, and I'm trying to understand if it's either or both and as it relates to these use restricted accounts and the bond for the conservator. Is it that the conservator needs both? They need to put the money, the asset, no, that's what I'm trying to get clarity on. If you could all help me with that.
Yes, it is either or, so either a restricted account or a bond, and that would be up to the judge's discretion.
And that's the conservator and not the guardian?
Both.
It's both? Mm-hmm. Okay. It's both that have to ensure that the funds get placed in a restricted account? I thought the conservators want to deal with the money, so that's why I'm trying to be clear.
If I could just clarify, are you talking about in instances where there are separate parties, one of which is serving as the guardian and one of which is serving as the conservator? Typically how that operates in the state of Michigan as it stands is the conservator would carry the responsibility, and the guardian would only be overseeing the individual's care outside of finances.
Rep. Johnson?
Thank you. Could you just clarify when, and I guess this is a little bit of a tangent, but when is a family member chosen and when is professional agency? What's the marker to go one direction or another? Or is the family given first option, and if they don't qualify or no one really wants to do it, then it goes to professional?
I would say that if the individual has a preference for someone, the court would look at that preference first. It's been my experience anyway. If those parties are found to not be suitable or to be unwilling or just unable to do that, then they would look for a third party. Generally, it's been my experience that the family is given preferential treatment.
I would back that up, and I would also add to that, in my experience, going back 10 years. I would say the majority of the time, the courts start with a family member, and either it goes south for various reasons. I know in my experience, it's not uncommon for that to go south because of financial exploitation, in which case a public guardian would be appointed as a second guardian for that individual.
As nonprofit entities, both of our agencies really serve as like the organization of last resort for all of our individuals. So we are called upon when there is no one else, no other option in our counties.
Thank you for your testimony. We appreciate you being here. Thank you. We have a couple cards to read in, and some people would like to testify. We have Cynthia Mifsud, who opposed the bill. Sis Rosalind Harris. She opposes the bill and would like to speak. Or she's neutral, actually. Okay.
Thank you all for the work you have put forth. The problem we have here is there is no oversight in place to confirm the accuracy and the integrity of the conservator accounting. In my own mother's case, my attorney and I challenged several financial errors I discovered on the court-appointed conservator's accounting. This cost me time and additional attorney fees. Until there is official oversight, we will still have these gaps. And until someone at JTC hold the judges accountable, our vulnerable will continue to be harmed. We must move forward and find solutions to close the gaps to protect our most vulnerable. Thank you.
Thank you very much for your testimony and for coming in. And we'll now move on to, are you ready now? Yes. Okay. Cynthia Mifsud.
Cynthia Mifsud.
Okay, go ahead.
Okay, good afternoon, Chair and members of the committee. I'm Cynthia Mifsud. Oh, sorry. Okay. Okay, can you hear me now? Okay. My name is Cynthia Mifsud. I'm the court-appointed guardian. I'm a daughter, and I'm an advocate with the Michigan Judicial Probate Integrity Project that I started with my fellow advocates. I am here in opposition to the House bills 5739 and 5740. Nobody has addressed the elephant in the room in all these problems that we have. The elephant in the room is the judge. In the Cornett case that Representative DeBoyer spoke of, the accountings were approved for 10 years by a judge. And it's rubber stamped. These accounts are rubber stamped by these judges and approved over and over and over again. And until the judges, the indiscretions in the judges' rulings are what is looked at and they're held accountable, you can write all the bills you want to write, and they're not worth the paper they're written on, because it's not, you need more bills, you need more laws. It's the judge is not following the law. Had the judge followed the law in the Cornett case, it would have never been a problem. Rose Bird would have been protected, but they did not follow
different
the
legislation.
law. Pardon me?
I think that's different legislation that we would have to consider, but go
Well,
ahead.
I mean, I would think it could be added to this legislation that it doesn't matter. I mean, you can add a bond, you can do all these things, but if the judge is the one up there rubber stamping these accountings and approving things, it's not going to make any difference. You're still going to have the same problems. These judges are manufacturing conflict in families so that they can introduce a public guardian, introduce a for-profit guardian, conservator, trustee. In my own case, they introduced a granddaughter who was not the next of kin, wasn't an interested party, and allowed her conflict with me who was the durable power of attorney and trustee of the trust, to usurp my role. And my mother was isolated for 14 months from my family, from my two brothers, our kids. My mother had lived with me for 2 years. And to allow these things to happen, and there's no oversight. I have over $200,000 it cost me to finally get my mother home. And of course, I feel it's worth every penny, but I didn't even get her home through the attorneys that I hired. I got her home when I finally went pro se and got my voice. I was able to get my own voice, use my voice in court, and I got my mother home. But I got my mother home a week after she had a massive stroke, and now she has the mind of a child. That's not fair. That's not justice, and that's not how anybody in Michigan would want their end of life to be, or the end of life for someone they love. So, I mean, I had a script here, but I went off script because I'm just infuriated that I appreciate you doing these bills. I do appreciate it, but if you're not going to address the biggest problem of all, it's pointless.
Well, I'm sorry that you went through that. Nobody should go through a situation like that. We obviously have a lot to do in this area. This is a start.
But we want a seat at the table. You know, we're the victims. We know what needs to be done. We want to work with you. We don't want anyone to go through what we went through. Nobody should have to suffer like that. My mother, her guardian ad litem billed my mom's estate $50,000 after harming her. The court-appointed attorney billed my mom's estate $68,000 after harming her. My mom only had $200,000. She didn't even have a lot of money, and now she needs 24/7 care. Where's the money going to come from? You know? So.
Yes, again, I'm sorry this happened to you. There's a lot more we have to do in this area. Maybe we can get together and.
I would appreciate it.
Sure.
I would appreciate
and
it.
why don't you contact my office and we'll talk about this. Thank
All right.
you
Thank
for
you.
your testimony.
Thank you.
We also have someone else who would like to testify. It's Tom Howe.
Thank you, Chair Schmaltz. I appreciate the time coming here today. My family was involved in the Genesee County, a disaster in the probate court, and my mom ended up being, had her neck broke at a nursing home and her pelvis broke, and then 6 days after that, her house was embezzled, which was my house. The day she died, her revocable trust in her house became my house as a beneficiary. And then the court-appointed attorney with the judge, they sold my mom's house, and now I'm in court, and I just made the Michigan Lawyer Weekly here this last week, and my case is in federal court against First American Title Company, who is the appears to be the Michigan Bar Association's favorite closing company, title company. They didn't do a title search. They do a title search on what they want. They falsified the trust. They falsified the documentation as if my mom was alive 6 days after she died. And I filed 1983 and 1985 charges as state actors, which got dismissed, which I'm having them. I'm going in for a change of my federal complaint, amending my federal complaint and having them, and all the state charges, which there's a $500,000 federal penalty in this for violating the insurance fraud laws in the state of Michigan. And so we know Genesee County with the judge there. She's running a RICO theft ring operation with several of her attorney friends that they all graduated from Cooley Law School. And they're all involved in my case. And the Attorney General won't do anything about it. And I've lined out the whole case in criminal law, what they did. So the issue here in that case was that the legislature has to come to the final conclusion that they have to implement what's in the state constitution is impeach these judges. There's no recourse in this. So this is way more difficult than what this one bill will do. And I like these bills, and I have some updates to them. And The second case was I had a sister-in-law who embezzled $700,000 in St. Joseph, Michigan from my in-laws, and she bought the shopping plaza across from the court, and she bought 6 or 7 Airbnbs, including her own personal house, out of my in-laws' assets. And so during this process, we were at the Berrien County Courthouse, and we have a usurper judge there, and the governor failed to appoint a proper judge. There's a circuit court judge who retired early, and he was that vacancy has to be, according to the Constitution, appointed by the judge or by the governor, which never happened. So the chief judge moved the probate judge over to the circuit court judge and put a district court judge in place of the probate judge, so they could screw my wife in the lawsuit there, and they dismissed the lawsuit. We went to Houghton County, which is where they lived in Upper Michigan by Michigan Tech, and the judge up there committed fraud, and he's now under investigation by the Judicial Tenure Commission. And so hopefully they'll be prosecuting him and Judge Janka for their RICO theft ring operation that they're trying to do, because they're trying to put the trust assets, which is the shopping plaza across from the court, as part of the St. Joseph master plan to acquire that property so they can expand the courthouse. And so this is how crooked this whole system is. And once you put this all in perspective of how crooked it is, these are great bills, and these are good starts. But this isn't going to get fixed the easy way. And so it doesn't matter what bills you do. These people don't care. They take advantage of high net worth families and embezzle their assets. Okay? My mom's case was over $800,000+ plus all my legal bills, which were several $100,000. I still ended up hauling a dead body out of a Bella Vita nursing home in Grand Blanc, Michigan. Okay? And she was held hostage during COVID. Right during the peak of COVID, they put her in the nursing home. And I was begging them to take over my mother's care. So part of this here is as I would get back to this whole thing here, is that I want to add a piece in this which says the legislative intent, which has never ever been clear in any of these bills. It's the intent of the legislature that the state shall not interfere with the private affairs of Michigan families in the appointment of a guardian or conservator unless the ward is at demonstrable risk of financial or physical abuse supported by verified complaints, substantiated reports, or court findings. A qualified family member who is willing to serve and has no criminal history shall be appointed as guardian or conservator unless the court makes specific findings on the record that such appointment would be not in the ward's best interest due to unfitness or verified risk of harm. And we need to have a statement in there of what the intent is, because what these people are doing is they're human trafficking high net worth families. And my mom, although she had all the proper planning done, I was her health care and financial power of attorney with my wife. We had irrevocable trust. We had everything set up perfect, and we had their attorney group. It was called Christensen and Federline. And this Mr. Christensen now is on the board of directors of the Michigan Bar Association. He's a family lawyer, and he's basically, in my opinion, a human trafficker of children. And he these things are happening today in our society.
Well, pertinent to our bills, we are putting safeguards on to protect vulnerable people from guardians or conservators financially. But I understand you have a certain court case, and we can't comment on that.
Right.
I know you're talking to Rep. DeBoyer to help you out with that. So that's.
But we need to put in this bond here is mandatory, not may. It's shall, mandatory. Okay,
Yes.
Because, and then in these bonds, I don't know what's in these bonds, and I don't think anybody here does. So what's in these bonds, and how do these bonds require that these accountings, are they done to whatever the bond's specific requirements are? Because in my case, and there was never any accounting done with any receipts whatsoever. They're all falsified information.
Well, we're hoping to change that with these safeguards and reporting and oversight. If you would also like to contact my office, we can sit down and go through, see what we can do to.
I've made some updates here for you, and I'd like to give them to you.
Sure.
And you can read them, and I'll forward you the electronic version of them.
And I appreciate your testimony, and I'm sorry that you've gone through such hardship.
And so part of this as we go forward, what we're talking to Jay about is also there needs to be restitution for all these families. This has been going on with the change with the Tom Boyer, with changing the court system and have the state pay for this court and this cost savings and everything else. And a lot of this stuff, I've given a package to Representative Johnson, and there's a lot of changes that need to be happening because I'm sorry, you cannot trust a state bar member on the bench in the probate court. It's a wild west show out there, and they're trafficking high net families for bar membership profit. And they don't care.
We'll sit down and talk to you about this sometime in the future.
I appreciate that because this is you know, and I like your bills, and I'm just saying that I made some updates. I think some of it you will like.
We'll take a look at
and
that.
then we can go from there. But I know this is opening around, and we need to have all this discussion on the table. We've tried for 5 years with never getting any progress whatsoever in changing this, and the situation has gotten from horrible to desperate now out there in the court system. It's absolutely
Well, we'll sit down and discuss some of these issues with you. So thank you again for coming. I appreciate it. And again, I'm sorry you went through everything you're going through. We have some other cards to read in support of the bill. Charlene Disler, Probate Support Specialist. Alan Bolter, CMH Association of Michigan. Jason Lakowski, AARP of Michigan. Okay, next we'll be voting on House Bill 5456 and 5457. We have one card to read in. In support of the bill, we have Derek Plumke, Veterans of Foreign Wars. Okay. Rep. Fox moves to report House Bill 5456 as substitute H1 with the recommendation it be referred to the Committee on Rules. Will the clerk please take the roll?
Chair Schmaltz.
Yes.
Representative Wozniak.
Yeah.
Fox.
Yep.
Johnson.
Yes.
Thompson.
Yes.
Pavlo.
Yes.
Wolford.
Yes.
Young.
Pass.
Burns.
Pass.
Rangens.
Is this on the substitute that just refers it to rules? No.
Song. Pass. Madam Chair, you have 7 yeas, 1 nay, 3 pass. The motion prevails.
Thank you, Madam Clerk. The vote has passed, and House Bill 5456 as a substitute H1 is reported to the floor with recommendation that it be referred to the Committee on Rules. Rep. Wolford moves to report House Bill 5457 to the floor with recommendation. Will the clerk please take the roll?
Chair Schmaltz.
Yes.
Representative Wozniak.
Yeah.
Fox.
Yep.
Johnson.
Yes.
Thompson.
Yes.
Pavlo.
Yes.
Wolford.
Yes.
Young.
Pass.
Burns.
Pass.
Rangens.
Pass.
Song.
Pass.
Madam Chair, you have 7 yeas, 0 nays, 4 pass. The motion prevails.
Thank you, Madam Clerk. The vote has passed, and House Bill 5457 is reported to the floor with recommendation. Rep. Pavlov moves to excuse absent members without objection. So ordered. Thank you. There being no further business before the committee will stand adjourned.